So, sir, as I had requested you, I am really thankful to you for kindly considering me to deliver this lecture on this Safari Retreat judgment. And also, sir, in this Safari Retreat judgment, one of the very important and fascinating aspect of this judgment is that in paragraph 25 of the judgment, the rules regarding interpretation of taxing statutes have been laid down in general. So that is
Yes.
something I think everyone will benefit.
Yes, right.
If you, sir, kindly deliver.
It's a good summary.
Yes, sir. It's a very nice summary. So before we start the session, even though Datar sir needs no introduction, but I would like to say a few words about sir. Uh, Sir is a true legend of the Supreme Court bar, and while he began his journey as a tax lawyer, but his contribution to various branches of law is so immense that I'm very sure that whenever the history of the Supreme Court is written, his name will figure prominently among the giants of the bar of the Supreme Court. And Sir has authored books not only on the Constitution of India, Central Excise, but he serves as editor-in-chief of the Ramya's Guide to the Companies Act. Sir is founder director of Nani Palkiwala Arbitration Center, and Sir's journey is truly fascinating for a first generation lawyer like me, because Sir rose from the ranks starting from his journey in the Madras High Court to becoming one of the topmost junior of the Supreme Court. Apart from all these things, one of the most admirable aspect of Sir, which I would like to talk about is perhaps he is one of the easiest senior to brief in the corridors of Supreme Court, because there is no formal process or rigid rules like many of the senior have their own rules to brief them. Whether it is in the evening, whenever we wanted to have a conference with him right before the matter is about to be called out, or even during the lunch break, Sir was always calm and composed, and Sir possesses a terrific sense of humor. And one of the incident which I would like to share, that during one lunch break, and Vipin Sir was there, Vipin Jain Sir, and we were having a very intense discussion about the matter which was just about to be called out in the second half. Venkatraman Sir walked in, who was representing the Union of India, and he asked whether he could sit next to us. And Sir, in his characteristic wit, immediately quipped that why not? You will also learn the correct process in the law in the process. So, Sir's remarkable, this fascinating, calm and composed manner, which always eases everybody around him also, and it makes the matter very, even though the matter is heavy, but the atmosphere is always light. So, sir, just I want to point out that this Safari Retreat judgment, Sir argued in white saffron matter. It was a Article 32 writ, and which we filed after this Safari Retreat matter was listed, and we consulted Sir, and with Sir's guidance, we decided to file a Article 32 writ, got it tagged with the Safari Retreat matter, and it is in this matter where Sir formulated this and decided rather that he will not press for the constitutional validity. Let Abrutos Sir, who was leading the matter for Safari Retreat, argue on the point of constitutional validity. Sir said that I will focus only on the interpretation, that the difference between clause C of section 17.5 and clause D, and he did not touch upon the constitutional aspect at all. So now I will leave it to Sir to discuss about this, what Sir argued and how we got the judgment in our favor. Sir, over to you, sir.
Thank you, Vinay. Good morning to all of you. I can see so many friends. I can see my friend Ravi also there. I can see other people also. Good morning, a warm welcome and happy Diwali greetings in advance, in case I forget at the end. So I'll wish you in the beginning itself. I must honestly say that this judgment could not have been, we could not have worked so well cohesively as a team. But for the help of Vipin Jain, Vinay Shraff, I think we all worked as a team. We got input from everybody. And as he put it, when the matter first started, we discussed the matter, and I think one meeting we had, and the matter was going to come next week. So when I came back to Madras, I was working on the planning the strategy, and I felt that one second. Yeah, I felt that the argument for challenging the validity itself will be very difficult, because after 4 decades of practice, it is extremely difficult to challenge a statutory provision. It is even more difficult to challenge a tax provision, because they say it's free play in the joints, government must have maximum leeway, this, that, and so on. And I thought that we could perhaps win on the basis of reading down the judgment. And I decided to focus on the difference between plant and machinery and plant or machinery. Vinay and Vipin all gave me the GST council meetings and so on. So here was an advantage of also having some experience in income tax. And I knew that the word plant has a very, very wide meaning under the Income Tax Act. In fact, in 1982-83, I had written a detailed article on what is the meaning of plant. It is not just an immovable structure. A dry dock is a plant. A fishing pond is a plant. Anything with which you can do business is a plant. In fact, the first decision on what is a plant is a judgment of Lord Rinley in 1886 or 1887, where he held a mule, there's a horse, is a plant, because he said something with which you do your business is a plant, something in which you do business is not a plant. So like a go down, etc. is not a plant, but any instrument of earning capacity will be a plant. And that article I wrote back, and subsequently there are a number of judgments which you can see under the Income Tax Act and definition of plant. And I decided that as a strategy, let us focus on plant and machinery, plant or machinery. And let us try to tell the court that, look, when you use the word plant or machinery, then the word plant is not defined. So you must understand it as it has been interpreted by the Supreme Court and the High Courts. You must jurisprudentially understand it as you have understood in various cases. We also found that plant or machinery is used only once, but plant and machinery is used at 10 times in the various sections. So we said that when they definitely wanted to use plant or machinery, there is a deliberate intent. There is a purpose for using such a word. And when they define the explanation, they put plant and machinery. They could have used plant or machinery also. So luckily that strategy worked. I was expecting that they may not uphold the validity, they may not strike down the validity. That also went according to what I was expecting the court to say. And finally, we succeeded, because apart from the law, you see, the whole point is that the government doesn't realize that just collecting more and more tax is not the answer. You are causing long-term damage to the economy. If you're going to have cement and steel at 28%, you're going to levy GST on the rent. But then you will say, I'll not allow input tax credit. What are you doing? You're only making our own cost of doing business much, much more. Just imagine if I have a logistics warehouse, you don't allow input credit. What happens? I'll only pass it on to the customer. Right? So, and I've always been fighting, apart from this webinar, I've always been fighting that, don't just focus on what is the GST loss. See that you may give up GST, but you'll get so much more by other indirect methods, through income tax, through other provisions of law. If your mall is cheaper, you'll have more footfalls, you'll have more business. See the overall ecosystem and just don't focus on only GST or income tax. So coming back to the topic, we finally succeeded on this issue of plant or machinery. Those of you who have read the judgment, as Vinay put it, one important takeaway is, in all future cases, when you're interpreting taxing statute, you have a ready-made summary where I appreciate the Supreme Court for taking the trouble of culling out the essential principles. So this will be useful not only in the high courts and the tribunals, wherever we have to argue cases before the judicial fora or the quasi-judicial fora, we can use this judgment. Secondly, this judgment highlights the fact that when distinct expressions are used. In some places you use plant and machinery, some places use plant or machinery. Then there is a purpose behind it. It is not a mistake as the union tried to argue it's a clerical mistake or a arithmetical mistake. No, that is not the. So second takeaway is be very careful of the. Third important lesson is, which I also was told and what Mr. Palkhiwala has to do was, more than going to hundreds of authorities, try to read again and again the statutory provision. Keep on focusing on the statutory provision. Read it again and again. So you will get some answers. There's a story I'll share with you. There's a leading criminal lawyer called V. Litharaj in Madras. He said, after so many years, whenever he had to argue a murder appeal, he would read 302, 304 again and again. So I try to follow it. If I'm doing Section 32 Income Tax Act, I try to read the section first, see the section. And in a statute, every comma, every full stop counts, a semicolon counts, and so on. So that's the third takeaway. Expression is very used. And the third thing is, you see, when you have a GST, try to see how this word is used in other taxing statutes. There is a cross-fertilization, if I may say so. Now, if you see the judgment, most of the judgment which has helped success in the case are income tax judgments. The Karnataka power judgment, that fishing pond judgment. Yes. So, those of us who are doing indirect taxes, also please refer to direct taxation. If you're doing income tax, try to refer to excise. When I was doing income tax excise, I used till manufacture was defined in Income Tax Act. We would take into account central excise definitions of manufacture. If the word is sale, try to see what is the meaning of the word sale, because these are what is called in law nomen juris. These are words which are definite legal connotation, not just English words like sale or manufacture. Manufacture, in as per the DCM case, is something which results in a new product, new use, new name. So the point I'm trying to make for all our benefit, because we are all students. We are all students. Every day is a learning process. So the thing is that try to see how the word is used in different statutes. There is, of course, once one Income Tax Act defines manufacture, then there is no need to go to excise. But if it is not defined, like in this case, plant was not defined, income tax came to the rescue, right? So this is the point. Now, going forward, what the court has said is they have applied that functionality test, which is again a landmark ruling, and it's a important development in tax jurisprudence. Functionality test. How do you decide what is a plant? So what is the function of that immobile property? Because all this difficulty came only in immobile structures. And plant and machinery, they have defined immobile structures to exclude. They say the civil works will not get it. Ordinary, the lathe or the generator fixed on it will be allowed. But they've excluded, if I'm not mistaken, telecom towers. One second, sir. Telecom towers.
They have excluded, sir, hotel and cinema.
No. In the section.
In section, yes, sir.
Yeah, they have telecom towers, pipelines, and land building and civil structures.
Correct, sir.
Explanation, yeah. And we consciously, I think, if I correct Vinay, we said, see, now we have to get success for our client. We are not arguing in general. This is not a tax seminar. So we are not bothered what happens to theaters and hotels, because they are not before us, and most important, they are not our clients. So we have to fight a general battle and get some overall thing. So other thing which you can also I learned over the years is have a laser focus on what your client's interest is and stick to that. So you don't have to go into general principles and so these are the basic points. So principles of taxation, cross-fertilization of tax laws, functionality test, and the judgment also, what has happened is it has now left room for interpretation. On shopping malls, it has sent it back. And I think Vinay and others got me the Maharashtra rules on shopping malls, because we said, why is shopping mall different from a pure commercial building? Because shopping mall has separate building guidelines, building rules, etc., which makes it a thing not just for commercial renting, but it is for having shops, you have theaters, you have food, etc. So it has a special function. I don't know what the Orissa High Court will do now, but it'll be interesting to argue on functionality test. I only hope that they don't amend the law retrospectively in the next budget and say plant and machinery is the same as plant or machinery, then we are all finished. Yeah. So this is the broad picture. If anybody wants to say something, we can.
Sir, I want to
See,
ask
Vinay,
you.
what I thought was instead of me giving, I would like to get your reactions also. I would like to learn also from all practitioners. Most of you are tax practitioners, so it will be a good experience for me also to learn your views here.
Sir, one thing just I would like to ask you,
Hmm.
that this functionality test,
Hmm.
you remember that last week only we argued on this Samta paper matter, that
Hmm.
whether factory said satisfies the definition of the functionality test, and Supreme Court, as in this particular matter, referred the matter back to the assessing authority that you take the call in accordance with law. So,
Yeah.
what is
Yeah,
your take on that?
no. Justice Oak said let the High Court also do some work.
Yes, yes, yes.
Yeah.
So, what is your view on that? Whether factory said will satisfy
Actually,
this?
in my opinion, for a factory, we got a much stronger case than a shopping mall also. Because
Yes,
factory, first of all, it can be dismantled and taken away. And if a warehouse is a generating plant is plant and machinery, then a pure factory shed or factory structure will definitely be entitled for the benefit. It would satisfy, in my opinion, the functionality test.
right, sir. So, sir, one thing I want to ask you, like we did not argue for hotel or cinema owner,
Hmm.
and hotel and cinema owner was not our client, so we're not concerned with the fate of hotel and cinema owner.
Hmm.
And the questions which are framed in paragraph 24,
Hmm.
it only frames three questions: whether the definition of plant and machinery in the explanation expanded.
One second. Para 24, no?
Yes, sir.
Yeah, that is on page 31. Yeah, correct.
Page 31, sir.
Yeah, please go ahead.
So it says that considering the submission made by the parties, the following main questions arise for consideration: whether the definition of plant and machinery in the explanation appended to section 17 applies to expression plant or machinery used in clause D. If it is held that the explanation does not apply, what is the meaning of the word plant? And whether clause C and D of 17.5 and 16.4 of the CGST Act are unconstitutional. There are two things I would like to ask you. One is that nobody argued section 16.4, and the validity of 16.4 has also been upheld while it is still pending with the Justice Nagratna, the constitutional validity part of section 16.4. And secondly,
I didn't know that. I didn't know that. But nobody argued, is it?
nobody argued section 16.4.
No, but
And
it must have been in some prayer. Some writ petition may have challenged
it was there in the prayer, sir. It was there in the prayer.
Hmm.
And secondly, sir, this hotel and cinema owner aspect,
Hmm.
that also nobody argued. There is no recording of the argument in the judgment. Also, in the entire judgment I have seen, there is no the question, the issue has not been framed while it has been answered. So, do you think that this the exclusion of hotel and cinema owner can be considered as an obiter dicta, or whether this validity of 16.4 being
When the
decided?
paragraph Anand Theatres Act, I remember I cited Anand Theatres.
Yes, we cited Advocate later.
Yes. See, I'll tell you what, if it has been excluded for income tax as a plant,
Yes,
then it is very unlikely it will be allowed here. There's no point arguing because that I think Anand Theatres was a three-judge bench.
yes, correct.
Yes. So, see, I'll tell you what, the whole thing is nobody even in service tax regime wanted
Yes,
ITC on a building.
yes, sir.
Or otherwise, if you take building, just because you pay GST, see, one argument is because I'm paying GST on the rent, I should get input credit. That is not the
Yes,
logic. The logic is
correct.
not that because the output is taxable, therefore the input is eligible. That is not the logic. So we succeeded on the technical point of what is a plant because it's an instrument of business. Now,
Correct,
for a
sir.
shopkeeper, his shop also is business, but that's not the intention to get into GST. Because if it's a shop, he will not get depreciation under Appendix 1 as a plant in Income Tax Act. He will also not get it here. That is my view. Because here there's some observations in para 62 or something that if the rental income is entitled, then ITC will be allowable. But I don't think that can be extended to a theater or a... See, technically speaking, a cinema theater could be a plant because it's a very specially designed building with special features and so on.
Yes, sir.
But a hotel also in that sense, but hotel has been closed by the Supreme Court as a...
Yes, sir.
Yes. Yeah,
Sir, one more.
Mr. Sandeep wants to ask, and who's going to monitor the question because I'm getting something on the chat box also. Somebody can monitor so we can answer the
No,
questions.
I will take care of
Yeah,
it.
please. Yeah. Yes, Mr. Sajdev, tell me. You're mute.
Please unmute yourself.
Yeah, sorry. Yes, sir. Good morning.
Good morning.
Sir, my question is, because in Anand Theatre, it has been clearly said that irrespective of the nature of the building, the hotel and theatre will continue to be a building. It will never be a plant. Now, my questions are two. One, what will happen in case of hotel? It means they are out of D, they will continue to be governed by C, and whatever is like left and other things.
They will not be covered in C. They won't come under D.
Yeah, they won't come under D.
D.
Now, if we apply the ratio
Hmm.
of Anand Theatre,
Hmm.
if we apply the ratio, and even the matter will go back to Odisha High Court.
Hmm.
If that specialized building,
Hmm.
if theatre and hotel are not a plant,
Hmm.
Supreme Court has said that functionality test is there.
Hmm.
If these two nature of specialized building are not plant,
Hmm.
then how come mall and other things will fit into the definition of plant or machinery? Because the test laid down in Anand Theatre has been endorsed by the Supreme Court in this case. Okay, they said that with respect to this Karnataka power and all, that will continue to be a plant. They said that that test is limited, but the functionality test, after going through everything, they still said it is a building.
Hmm.
And what will happen on that, and what will happen in case of hotel? Because there's huge amount involved in hotel, and I'm separately talking to you for some other matter, which the matter is pending in the Supreme Court. SLP has been filed. That is a hotel issue. Okay. Now with this, I just want you to take your thoughts on that.
See, the word here is plant. There is no definition in GST.
Yes.
If another bench has held it not to be a plant, then unless it goes now to 5 judges, you're not going to succeed as far as the hotel is concerned. Now, they applied functionality test in the context of doing business. Now, technically speaking, if if you see the Income Tax Act, basically it's more of industrial type of building which has got the benefit, not pure commercial building like a hotel or a plant. Shopping mall also, I don't know how the functionality test is going to be applied. We'll have to just check. But if it's a dry dock, if it's a factory, if it is a logistics warehouse, if it's a cold storage plant, all this will pass muster. We will sail through. The true test will be when it is substantially like a hotel or like a theatre. What will happen? Hotel theatre now is a separate class. It's closed. So you can't expect to succeed. It will be very difficult because they will say that, look, yes. As one chat box, functional test is special technical requirement. Not for engineering purposes or for other purposes, you require a plant. Actually, if you ask me frankly, telecom tower is the classic example of plant. But they specifically excluded it. Telecom tower is a plant. Yeah. So I think you will not be able to succeed in Binal Cinema because of Anand Theatres. And the court is not going to break its head and try to give a solution. They will say we'll follow Anand and we'll close it.
Okay. Okay, sir. Thank you.
Thank you.
Sir, one question I would like to ask is, with respect to the interpretation of the rules which have been given in paragraph 25 of the judgment, is 32, sir, of the judgment.
Para 32.
Paragraph 25, page 32, sir.
Page 32.
Yeah. Rules regarding the interpretation of taxation.
Rules of interpretation. I thought.
Correct. So I have few questions with respect to the rules of the interpretation of the taxing statutes. The first rule which has been cited here is that a taxing statute must be read as if with no addition and subtractions on the ground of legislative intent or otherwise. And further, paragraph B says that if the language of the provision is plain, the consequence of giving effect to it may lead to some absurd danger is not a factor to be considered when interpreting the provision. It is for the legislature to step in and remove the absurdity. But, sir, in paragraph I, it says that the literal interpretation is manifestly unjust, which produces a result not intended by the legislature. Only in such a case can the court modify the language. So, how do we reconcile this paragraph I with paragraph A and B, where it says that it is for the legislature to step in and remove the absurdity, whereas the paragraph I says that if the literal interpretation leads to manifestly unjust result, then the court can step in. So, how do we reconcile this?
Definitely, there is a basic conflict in those two propositions. Partly, yes. What B says is, in fact, in B also, if you read, if you take Kanga and Palkiola, in the commentary we have edited, section 1 contains a very detailed list of interpretation. Those readers would also please have a copy of GP Singh's interpretation, which has got a most exhaustive, which perhaps the world's best book on interpretation is GP Singh.
Correct.
So where they say that if the result is going to be something absurd, the point is, it's not absurdity per se, but if the result is absurd in the sense that legislature never intended this to happen, then the court can step in and give what is called a purposive interpretation. JH class cases there, other cases are there. So, because what the court will do, they will not strike down the law, they will read it slightly differently to mean that. And the classic example, which many people don't know, is this Indian Oil Corporation versus Rajgopalan, where what's the meaning of capital employed? No? So there's no time now, but where they said if you take a literal interpretation, you'll never get the income tax deduction. Because what happened in that case was they said capital employed, it was for development allowance. You set up a new factory, you'll get development allowance on the capital employed in the new factory. Okay?
Yes, sir.
The absurdity of the statute was, they said, this is very important, investment in the new factory as reduced by the borrowings of the SSE. So borrowing of the SSE will be the entire SSE. So if I put up a refinery in, say, Mathura and put 1,000 crores, but my borrowings are 5,000 crores, then so the court said it should be read as investment in Mathura minus borrowings from Mathura. Because otherwise you will never get the benefit. Idea was to give development allowance to encourage. So that's the way they apply the purposive test. So it's not absurdity. It should be a absurdity in the sense, an intention which the legislature never contemplated. You see, ultimately Parliament doesn't make laws to make it meaningless. They have got a certain legislative intent.
Yes.
You can find out from the surroundings, and that's precisely why board circulars are issued. To like KP Varghese, what they said was if the purchase price is less than the guideline value is automatic. Then the board circular said for genuine transactions. So there are so many things like that. Yeah.
Yes, sir. Thank you, sir. Sir, one more question with respect to these rules regarding the interpretation of taxing statutes. This judgment says that if two interpretation of a statutory provisions are possible, the court ordinarily would interpret the provision in the favor of a taxpayer and against the revenue. Sir, paragraph D. Paragraph D. If two interpretation of a statutory provisions are possible, the court ordinarily would interpret the provision in favor of a taxpayer and against the revenue. Now, sir, we have this judgment in the case of this 5 judges bench judgment, Dilip Kumar and company, sir, where it says that exemption notification has to be interpreted strictly. Now, again, that judgment, sir, interestingly, in this by Justice Rohinton Nariman judgment, Mother Superior Adoration, Honorable Justice Nariman says that while it has to be interpreted strictly, but in that judgment, the Dilip Kumar judgment, the Honorable Supreme Court did not go into the long line of judgments where they distinguish the exemption provision generally and for the beneficial purpose. So, how do we reconcile these judgments, this judgment, and how do we get the best out of it?
Yeah, what
from the SSC's point of view.
Yes,
not from Venkatraman's point of view.
I don't have Dilip Kumar right now, but Dilip Kumar, there are certain passages where there's relaxation. They say for exemption, for chargeability, it should be strict, but where it's for a particular purpose, you can interpret that particular purpose.
Correct.
Right? So what Rohinton has done, and I think the judgment of Rohinton is that explain Dilip Kumar very well. See, they take Dilip Kumar like a parliamentary statue. They say
Right.
we strictly construed means they bring in some kind of rigidity.
Correct.
But Dilip Kumar doesn't say that the purposive test is wrong or anything. They simply say it's an exemption notification. Then construe it strictly. Suppose they say that about 5,000 tons you will not get the benefit. You can't say that for 5,010 or some technical reason I should get it. So the transaction nobody borrows because exemption is a case where the revenue is being lost to the exchequer. And when Parliament wants to give exemption, it consciously knows that it is going to lose revenue, but the loss is offset by a larger social purpose, or it may be for below the poverty line or whatever it may be. That's how they offset it. Now, what is the principal purpose? And then what in that all India mother thing of Written Arrangement,
Correct.
where it goes into building meant for nuns and things like that.
Correct.
That's
Correct.
the purpose. A very classic example is the Tata Oil Mill case, Justice Ranganathan judgment, where they say that you using there the case was edible oil prices were going up, and edible oil was being used to make soap. So to ensure that there is a disincentive, they said if you use non-edible oil like rapeseed oil, mango kernel oil, other non-edible oils, you will get 400 rupees per ton reduction in excise duty. Now they say use in the if an assessee uses non-edible oil in the manufacture of. Now what Tata Oil Mill did was they would get that non-edible oil, that rapeseed oil, done through a job worker, get the emulsification and bring it to the factory and use in the manufacture of soap. The department said it's an assessee doesn't contemplate job worker, therefore I will not give it. It's a very good judgment in Tata Oil Mills. Ranganathan says, what is the purpose of this? Purpose
Yes,
is to ensure that by using non-edible raw material, the edible oil prices to that extent pressure will be reduced on them, number one. And secondly, this mango kernel, I think otherwise just thrown into the junk. If they can be used and extracts and used, that's why they give 400 rupees. So the government is losing 400 rupees on soap per ton. But the advantage is using non-edible oil. So that's a very good case where they adopted the principal purpose test. Somebody in the chat also mentioned about this 1,500 square feet flat. Now, see again, little interpreted. I have not understood. No income. Basically, department will give a benefit and they will have 20 reasons to deny the benefit.
yes, sir.
They will say flat, then they'll say balcony is not included in the flat. You put 2 shops, therefore the flat has to be excluded. So, I don't know. I think ultimately if you apply your common sense and try to see why it is done, then it can be.
Right.
But recently
we can,
recently we did this coconut oil case also. The judgment is reserved. We say if you want to tax coconut oil,
Marico industry matter.
If you say coconut oil is used mainly for hair, amend the law. Amend the law.
Right. Sir, one question which arises from this judgment.
Just see
sir,
for the people who want to ask questions, because I'm seeing something on chat.
Yes, I will take them, sir.
Okay.
Just allow me to few questions. Sir, in this judgment, if you remember, Venkatraman Saab vehemently objected to our relying upon the income tax judgment. He was all along saying that how can you rely upon income tax judgments while the matter is GST. In the Income Tax Act, the ITC is never allowed. So the question of ITC not being there, how can we use the income tax judgment to canvass our case? And in this judgment, it has been said that when a word is used in the taxing statute, it has to be construed. It should be understood in its commercial sense. Unless it is defined in the statute itself, the word and expression in a taxing statutes have to be construed in a sense in which the person dealing with them understand. So how much, sir, can we borrow the definition from other statute? How much the judgment of other statutes can we rely upon? and to what extent the commercial meaning or the dictionary meaning we should refer to.
See, this is basically the skill of the advocate and also the interpretation by the judge. There is a case called PC Cherian versus Burfi Devi. I know because it's called Burfi Devi, like Jalebi.
Yes.
Yeah, so Burfi Devi. So there they say that typically the definition in one act should not be used for another. That is one principle set because each. Now there what you can do is you can find out what are the nature of statutes. Suppose there is one definition used, let's say in the Hindu Marriage Act. That
Right.
will not be so relevant for a taxing statute. But typically, they got taxing statutes. They are cognate provision. They all deal with taxing statutes. That's one point. Secondly, if it's a general word like sale, plant, right? The classic judgment is Gannon Dunkley. It is AR 58 Supreme Court 560,
Correct.
where the sale was not defined in the Constitution. Entry 54 said sale or purchase of goods.
Yes.
Now, what is sale? Even Article 366, which is the definition section, doesn't include sale. This is Venkatrama here. He makes a very elaborate explanation. He said, what is the sale? What is the meaning of sale? Will it include works contract? The question was, will sale include works contract? Then he says, sale is a term used in several years. You know, before Sale of Goods Act is 1930. Contract Act is 1872. The provisions of sale of goods were in the Contract Act up to 1930, 76 to 100 something up to bailment. That was removed and they formed the Sale of Goods Act. So sale was a term used in contract law. So he says, he used the word nomen juris, N-O-M-E-N, juris. So if a word is used, interpreted by the courts regularly, then you must understand in that word. Then he said sale was used in England, because England doesn't have the Contract Act, but it's just common law. We have defined the word sale in the Sale of Goods Act. And he says, when you say sale, you necessarily mean three things. You mean seller, buyer, that is transfer or transferee, goods, movable property, and thirdly, consideration in money. If it's consideration in kind, it becomes an exchange under 118 of the Transfer of Property Act. So if these three factors, that is transferor, transferee, goods, and money, then it's a sale. So like that plant, what I said was, if you're not defined plant, you also not defined machinery. So many words in GST has not been defined. So where do you go? So you'll have to go to, now for example, in GST, you got association of persons. In the definition of person, you got association of person. Where will you go? Now, suppose a person includes HUF, Hindu Undivided Family. Where will you? We go to the Hindu law. So you go to that particular relevant law and use it. So you can always take the benefit of other definitions into this act. You can also say, look, this definition is meant for that act. It will be incongruous or inconsistent applying it here. So it's a case on a case-to-case basis.
Right, sir. So now I will take some questions from the chat box. One of the question Mr. Muthu Kumar is asking is, I have received works contract services for construction of warehouse. Can I avail ITC? Goods or services or both used in section 17.5D, will it include works contract services?
Will it include works contract services? Works contract is coming in 17.5C, right?
Correct, sir.
So
75D, sir.
no, works contract. Works contract service. It's 17.5C. Or if that person can actually, because
Yes, sir. 17.5C.
yes, it's applied for construction of immovable property except where it's an input, so and so. So see, I'm telling you what, just for this safari retreats, just take the judgment for a limited purpose of saying that wherever it's a specialized structure, it will get the benefit of ITC.
Right.
Yeah, there's one question whether real estate sector should treat their projects. as-
Sir, I think one thing can we say,
Hmm.
like Schedule 2, it says that an activity has to be treated as per section 7.
Hmm.
A activity has to be treated either as a service or as supply of goods. It cannot be treated as a like in the erstwhile era where a works contract services, they could have been treated. We needed to vivisect the part of the service into labor and tax it in the service tax, and the part of the goods into to be taxed under the VAT Act. Now since it is a combined act, section 7 subsection 2 says that sorry, rather 1A says that when
No, I think works count is in 218 if I'm not mistaken. Section 2, subsection 118.
yes, that is where it is defined.
Hmm.
But in
It's taken
schedule
as no,
2,
it is taken as a service. Like fix, you take what is a service? Take sub 5. Construction of complex, etc. will be taken as a service.
sir, in schedule 2 clause 6 composite
Composite
supply,
supply, yes.
it says that the following composite supplies shall be treated as supply of services,
Service.
namely works contract.
Works contract, yeah.
So can we not take the benefit of this works contract service, saying that it is a service and goods or services are covered within section 17(5)(d)?
Hmm.
So if I'm using it, if my activity is satisfying the test of the functionality test,
Yes, you
then
can
I
say.
should get the benefit. There should be a
Yes.
liberal,
Yes,
I mean,
yes.
the
And
judgment itself.
Yes, as long as my output is a plant, that is meant for putting up a plant, not only purchase of goods but also purchase service also is applicable. Just as you will get the benefit of cement and steel, you should get the benefit of services also.
Correct. So works contract services, by deeming it to be service by virtue of schedule 2,
Yeah, it's an
I think
arguable
it
point.
should,
Though we didn't argue in so far it retreats, but it's definitely a point worth taking.
yes,
Because
sir, yes,
you can't complete that plant without goods plus services.
yes, sir. Uh, then Mr. Viswanathan is asking, once section 17(5) is notwithstanding 16(1), including concept of business, to what extent business aspect is relevant for plant or machinery?
See, what some people are asking is, you just come to schedule 2. They are saying that rental is a service. Renting building is a service. It's
Yes,
an output service. Therefore, can I get it? My answer is no, because that was not the intention in Safari Retreat. We focused expressly on plant as a specialized structures, not ordinary commercial buildings and so on. Because if cinema, theater and hotel can't get it, an ordinary building will not get it. So get the point. Yeah. So pure real estate projects, somebody just asked, I don't think it will pass muster to take IT parks, etc. as
then Mr. Arup Dasgupta is asking, what would be the way forward for this judgment for those RTPs who have availed the ITC but not utilized it? Means there are,
no, I mean, I often I can't say what when they took the ITC, when they won't utilize it. It will depend on their own case. I mean, I can't answer that offhand. Yeah. The point is you are eligible for credit. If otherwise, subject to limitation, other things, etc., you can utilize it now. Yeah. Anything else?
sir, I have some, my junior has framed some general questions for you. Sir, not related to this judgment or nothing to do with the interpretation of tax statutes and all that. Some general question for the benefit of
Yeah, I think
those.
somebody is putting his hand up. I don't know.
Yes, Mr. KS. Yes, Mr. KS, you can unmute yourself. You can unmute yourself. You are not muted. You have to unmute. Yes.
Yeah, you can hear me, sir? Yes.
Yeah.
Yes.
Thank you, Vinay, sir. Datar, sir, one question which I had with respect to the discussion we just did on 17.5C versus 17.5D on the works contract service. Now, 17.5D covers all the credits on goods and services which are used for, allows the credit on goods and services which are used for constructing plant. 17.5C specifically restricts credit on works contract services. Now, can someone say that because there is a specific restriction on 17.5C, you cannot take it as a eligible credit under 17.5D?
No, you can't, because 17.5C is for plant and machinery, whereas this is for plant or machinery. So you can take the advantage of it, because here it talks of goods or services. It talks of works contract services supplied for construction in more property other than plant and machinery, except as an input service for further supply of work. So you can say 17.5C is expressly related to works contract service for works contract service, where the input is works contract service and the output is works contract service. Suppose, for example, there is some works contract service which is necessary to put up a plant like a generation plant or a logistics warehouse, etc. Some works contract service is required. Then you can get the benefit, try to claim the benefit.
Thank you, sir.
Sir, few general question about the argument. I mean, I remember, sir, that I was fascinated by the manner in which you put up the arguments, the preparation for it. So, what is your advice for? I mean, to prepare for a matter, how do we prepare? What are the do's and don'ts to while arguing? And when you are dealing with so many matters at a time, how do you manage to divide your time between matters and your personal things?
No, see, on preparation, I prefer a structured approach. Suppose I'm dealing with a case. Let's say I'm dealing with Maharashtra VAT Act, hypothetically, in the Supreme Court. So what I basically do is I try to first go to the impugned judgment, because people start arguing straight away on the first point. We are in the Supreme Court, so to see what happened in the High Court, what happened in the tribunal, what are the basic issues there. So one is studying the impugned judgment in the High Court. In cases where it directly comes to Supreme Court, you see what the tribunal did. Right? Like recently, one matter of mine was admitted against me just because the tribunal simply reproduced out of 18 paragraphs, 16 paragraphs was reproducing some other case and coming to a conclusion. They said it's non-application of mine. So I try to see this can work in my favor when it's against me also. So first is study the High Court judgment or the impugned judgment. Then the other thing which is advisable for tax matters is you divide structure your argument into sections. What is the statutory provision? Suppose it says as may be prescribed, then try to see what are the rules. So primary legislation, delegated legislation, are there any board circulars? So that is the statute part. You make a mind map. So one is the statutory part. It will include the main act, the rules, the circulars, any office memorandum, press notes, etc. That will be the thing. And then secondly, we go to the earlier judgments of the Supreme Court, High Court. If it's an important Supreme Court judgment, then if it's a very heavy matter, then I take the trouble of reading the High Court judgment from where it came. Like if you see Gannon-Dunkerley in 58 Supreme Court, more useful to understand Gannon-Dunkerley is to read the Madras High Court judgment of AR 54 Madras, which became 58 Supreme Court. So if it's an important judgment, like say if it is Vodafone or the Supreme Court, then you must also read the High Court judgment. So you get the drift of how the matters went. Then you know what questions were unanswered by the Supreme Court, what questions were dealt with. So if it's a matter, it's better to read the particularly judgment which have been relied upon. That's the second part. Then that's part of Indian judgments. Then if it's like recently we did work on capital versus revenue. In capital versus revenue, then you got a lot of English cases are also there. So you go to English cases, see how they've been interpreted. Suppose the Indian Supreme Court has referred to, say, John versus Smith. I always try to go to John versus Smith and see what was that case. Then if it's an important case, what was the income tax law, the Schedule D, Schedule E, in what context they interpreted it. Especially if it's against you, then you can have to distinguish it. So that's how you make your notes and so on. So basically statutes, cases, Indian versus English, you keep splitting it and then you make your, and then you try to put your propositions in a particular manner. And finally, when arguing, I tried not to follow a structure because the judge may go off the tangent. He may try to see something else. You have to keep on following him. You don't have to, ultimately you have to persuade him, not
Yes.
show our learning. So some very often on, like the court may take off on some limitation point. So you answer that. And other thing which I have learned most is, I often sometimes make a mistake is, I learned from my seniors is never interrupt the judge. I find very often, before the judge asks a question, you are answering something else. Let him finish his question, wait. Then that's very, very important. Anybody else?
Yes, sir. There are a couple of questions. One, Mr. Ramani wants to ask you a question. I'm unmuting him. Mr. Ramani, please unmute yourself.
Yes, sir. So the question that I have is section 17(5)(d) talks about goods or services are both used for construction of immovable property other than plant and machinery on his own account. Now, sir, in para 32 of the Supreme Court ruling, Supreme Court has interpreted what is on his own account to mean that if it is being rented or leased out, then it is not on own account. So does that mean that, sir, if a building is being constructed and rented out, do I still get a credit? Because that 32 paragraph tells that, but there is no operative conclusion on that particular point at the end.
See, the point is this is people are now jumping around and saying, since I'm renting the building, it's not on my own account. So they want to start claiming credit for every building. That is a disastrous step. It is not, when Vinay and all argued, that was never our intention. Our intention was focused on specialized structures like plant and machinery, not on standard buildings. Secondly, you can't read a judgment like a statute. Otherwise, your answer is, if I construct 6 shops and I give it on rent and my income is more than 20 lakhs, then can I claim input credit in the shops? My answer is no, because we succeeded only by borrowing what was in the Income Tax Act. If you are going to be a building in the Income Tax Act under Appendix 1 to Rule 5 of the Income Tax rules, you will not get the credit here. But everybody is jumping, say, oh, take para 32, they say on his own account, therefore I'll start credit. It's good luck to you, but I don't think you should pursue that path. What will happen is eventually, such adventurism, the government will amend the law and everybody will lose their benefit.
Thank you, sir.
Mr. Spurs Bhargav wants to ask a question. Please unmute yourself.
Yeah, good morning, sir.
Hi, Spurs.
Hi, sir. I think one part of the question is already answered in terms of works contract service, whether it can be claimed under D, so which you have suggested may be possible. So what I wanted to ask secondly was whether it will be possible for SSCs, so other than, let's say, warehousing. So because in Supreme Court, what was argued was generally warehousing storage, where the specialized structures are built and then rented out. But there are other SSCs who may be building specialized structures, but let's say their output tax liability may be not per se renting or leasing, but under some other taxable service or output tax. So will it be possible for them to contend in their respective matters that based on the principles, ITC would still be available, even though my output tax is not under renting per se?
See, I don't know, I understand all the facts of what you're suggesting. I can't answer the question because the point is, what if I understand you correctly, what you're saying is, as long as my output is subject to GST, will it automatically input be eligible? Is that what your question is?
Yes, so provided it qualifies as plant.
Yes, again, if it's a plant, not building and not commercial structure.
No, it qualifies as plant, but let's say my output tax may be under, because of classification, not under renting, but some other category.
Yeah, then you should, because then you'll be out of 17(5)(d, no? No controversy will not be covered by, see, 17(5)(d), now the court is, ultimately what is the court done? They have defined plant to be anything which satisfies functionality test will get the benefit of 17(5)(d). You will not be hit by this immovable structure. The government's argument was, once it's immovable, they talk the breaking of the chain was the argument raised by the department, that once the immovable structure becomes ready, there's a chain is broken and thereafter ITC cannot be got. So there is no breaking of chain. You see where the building is. If it's a specialized plant as understood in income tax, I think the proper test, in my opinion, is, would this be a plant under IT law? If it is so, then you will get a very good chance of succeeding here. That could be a
Thank you, sir.
simple thumb rule.
Sir,
I
only 2
want to
minutes.
wind up at 12, so we can
Yes,
go.
sir. Yes.
I know it's time.
Yes, sir. So I think there are more people who wants to ask question, but
Go
I
ahead,
think,
we can go 5 more minutes. I'll just postpone that meeting. Go ahead.
okay, sir. So Mr. Aditya wants to ask a question. So I'm unmuting him.
Yeah.
Mr. Aditya, unmute yourself.
Good morning, sir. I have
Good
just
morning.
one question. Vinay sir was saying that if a person is taking works contract service, now if one looks at the language used in 17.5D, like goods and services used for construction of immovable property, my question is, so how does one put it this way that, yes, I am taking this works contract service, barring, despite the fact of the language of 17.5C, I can still fit in 17.5D. Obviously my construction is a plant. So I just wanted some color on this aspect, that how can persons now start
I'll tell
arguing
you
this
what,
way?
you are going to face resistance. The government is going to say that, look, we have confined works contract service only when it is used for other works contract service. So when we use the word service, see, this plant and machinery may go against us in plant. I'm saying it's an arguable case, but if I'm going to argue for the other side, what I will say is, when they use the word services in D and they use the word works contract services in C, obviously works contract services is a special category. It will be allowed only when it will be disallowed in all cases only when it is an input for further works contract service, you intend to allow it. That's one way the government will put it. One argument which in your favor is that the word service includes works contract service in Schedule 2, and therefore I should get the benefit. But this is going to be another contentious point which will rise in the coming months. When you go back, now the court has left it to the high courts and the tribunal or commissioner to decide. So in subsequent cases, this will be a problem. You will claim you will say service includes works contract service in 17.5D. Department will say no, works contract service will not be allowed except in the category mentioned in 17.5C.
Sir, last question I would like to take.
I hope I've answered Aditya's query.
Yes, sir, certainly. Sir, last question I would like to ask you, that people are talking about that there is a probability that the government might make the retrospective amendment. So on that aspect, my question to you is this, that we have this judgment of Jayam and Company which arose out of the Tamil Nadu VAT Act arising from the Madras High Court, where Section 19, subsection 20 was retrospectively amended. So if the sale price is less than the purchase price, then to that extent, the ITC was not allowed. So while Honorable Supreme Court upheld the amendment itself, but struck down the retrospective amendment, saying that you cannot take away vested right. When the law was there, then the credit accrued to me at that point of time on the basis of the law as it is at that point of time. So retrospective amendment was struck down. Prospective amendment was upheld. So what is your take on that, sir? That if suppose tomorrow the retrospective amendment is made and this plant or machinery word is amended to plant and machinery, and that explanation obviously gets applied to D also.
Again, it will be
can we take recourse to Jayam and Company saying that, okay,
yes, you can take, but department will rely on that Mohit Minerals, that other Mohit case where, no, sorry, VKC.
VKC footage. But this is a retrospective issue is not there.
No, we tried to request, but they didn't get into that issue at all because
they did not get, yes.
The rule was amended retrospectively.
Correct. That the court did not answer.
They did not go into this.
I think in VKC, one of the unfortunate aspect was that, as you had argued, the challenge of rule vis-a-vis the act, I think we had a greater chance of success. But the moment section 54...
actually, VKC, I argued towards the end when I gave my reply because you were hurrying us up. I said, look, please don't make it retrospective. Chandrachud said, yes, we'll consider, but I think he forgot about it. Yeah.
Yes.
So even when we did this mines and minerals matter in the 9 judges,
yes.
I stood up and said, what about prospectively? Then they had a special hearing for prospective retrospective. Now they said it will operate only from 2005 from Kesoram and so on. Yes. I don't know. I don't think government should make it retrospective. If at all they make it, they'll make it prospective. If they make it retrospective, yes. one other thing what industry should do is these chambers of commerce and all of you has said that I think all the chambers, they must try to put forth that there is no need for amending the law. You can also mention that how these structures, what's the benefit they get and how the rental will be lower. It will benefit if a logistics warehouse or a food cold storage plant, the rents are less. You can point out, and if you can just see through your association, show that the revenue loss is not so much. See,
I think, sir, one important aspect is that
no,
the
I'm
world,
saying my point is very often the industry, the chambers of commerce, unfortunately, don't say anything negative against the government. They're so scared. But if you can have a study and say that, look, this is the consequence. These are the beneficiaries of the judgment. What is the tax impact of the judgment? 500 crores. So don't make a retrospective amendment. For the government, everything is a retrospective amendment. They can never lose.
yes.
So you must then take up this judgment, have a PR exercise, get somebody to make studies, give to the government saying that don't make a retrospective, it will be counterproductive. And if you're going to collect 1 lakh crores a month, this is just 500 crores or 700 crores, not worth it.
And for prospective amendment also, I think the chambers can make a suggestion that the world over, the trend is to move towards the lease and license. The world over, people are moving away from buying properties. They are more into leasing and licensing. So if you are not allowing the credit on lease and license, then you are shutting down this mode of business altogether.
Correct.
And you are forcing people to buy, take loan from the bank and all that.
No, as it is, there's a complaint that everything is an extremely high cost here. So if you're going to make it worse, yeah.
So, sir, thank you so much. I mean, with so much of time and so many wide aspects we have covered in this session. I'm
Thank
so
you.
grateful to you, sir.
Yeah, sorry, I couldn't do it last week. I was held up. So this week we finally finished it. And
No, sir, this was better. Last week it was
Yeah.
more of a holiday going on in
Yeah,
Calcutta.
no, we had that one seminar for the whole day and an international seminar. Okay,
Yes.
thank you so much. Wish
Thank
all the
you.
best.
Thank you,
Bye.
sir. Thank you,
Bye.
sir. Thank you so much.
So one person has mentioned some judgment of the tribunal president. If they can just send it to you and send it to me, I'll just have a look at it. In some chat, I just saw, yeah.
Yes, sir. Yes.
I was not able to follow the chat box because I was speaking more to the persons. So,
Yes, sir.
okay.
Okay, sir. Thank you, sir.
Thank you. Have a nice weekend.
Thank you, sir.
Happy
Have a
Diwali.
nice weekend, sir. Thank you.
Happy Diwali also.
Happy Diwali, sir.
I'll just exit. Thanks. How do I exit? Exit.